This is Mike Franklin, the property tax guy, and today we're going to review some small claims assessment review cases I had down in Binghamton, in the Binghamton area. And what the topic I have today is that we've all noticed that the police have been adding body cameras all over the country, to hold the police and the public accountable. So it's just not, he said, she said, when there's an issue. And but the problem is that there's no equivalent for the judicial system, and it appears as though the judges in New York in particular don't like to be held. They don't like to be recorded. They don't like to be transparent and accountable about what it is that they're doing. They just want it to, it's so because they said so. They make their determination, and they don't want to be second judged on it. And I think that's inappropriate. I think that they need to be recorded with certain limitations. So I'm going to review it. So what I did was I had two cases down in Binghamton for some assessment matters in the town of Vestal. And the administrative judge for the 6th Judicial District, which consists of about 10 counties in the southern tier, Eugene Faughnan, I submitted a media request for him. I wanted to record the hearing. And so initially he denied me, saying that I was not a bona fide member of the press. So I want to review that. I've got some verbiage from a case law that the hearing officer provided, suggesting that case law supported their position that I am not to record these hearings, when in fact it supports my position that I can. But here's what it says. Though the public acquires information about trials chiefly through the press and electronic media, the press is not imbued with any special right of access. Rather, the media possesses the same right of access as the public, so that they may report what people in attendance have seen and heard. Thus, the press has no right to information about a trial superior to that of the general public. So he's denying me, saying I'm not a legitimate member of the press, even though this case law indicates that that the media and the public have the same rights. And that particular argument didn't work for him. So then he denied me based on, I wrote him an email and responded. So then he gets back and says, well, I'm denied because of New York State Real Property Tax Law 735. 735, no transcript of testimony shall be made of a small claims assessment review hearing. The hearing officer's decision of a petition for small claims assessment review shall not constitute precedent for any purpose or proceeding involving the parties or any other person or persons except as provided in Section 739 of this title. So it says no transcript. And what I did is I asked to video record the hearing. So what I have to explain to the administrative judge is root words, transcript, as in translate, as in script, as in write. So they're going to translate into writing is what a transcript is. It's got nothing to do with video recording. But the judge likes to use the ambiguity to say that you're denied because he said so. Well, 735 simply does not apply. 735 pertains to the assessment cases being decided based on determination, not precedent, and therefore no transcript is necessary. And this particular section, I believe, was written in 1982. I could be wrong about that, but it was quite a long time ago, and they didn't anticipate, such things. It's got nothing to do with video recording. It has to do with the cases being decided by determination. So that didn't work for him. So then he cites Section 131.1 of the Rules of the Administrative Judge. Section A. In order to maintain the broadest scope of public access to the courts, to preserve public confidence in the judiciary, and to foster public understanding of the role of the judicial branch in civil society, it is the policy of the unified court system to facilitate the audio-visual coverage of court proceedings to the fullest extent permitted by the New York Civil Rights Law and other statutes as interpreted by the New York courts pursuant to the rules set forth below. Okay, so that doesn't sound like an absolute ban on it, now does it? It says, in order to maintain the broadest scope of public access to the courts, to preserve public confidence in the judiciary, and to foster public understanding of the role of the judicial branch and civil society, it is the policy of the unified court system to facilitate the audiovisual coverage of court proceedings. And so, and as it pertains to, might be limited by Civil Rights Law 52. Now, keep in mind, civil rights laws are to protect people's rights. It's not to limit them. And so, but they're saying that the civil rights law does limit them. Well, we'll get into that. We'll get into that in a minute, because he denied me based on 131.1, and when that didn't work, then he went to 52. So let's continue on with 131.1. B, audiovisual coverage of proceedings in which the testimony of parties or witnesses by subpoena or other compulsory process is or may be taken is prohibited. See Civil Rights Law, Section 52. So in other words, the Civil Rights Law is protecting people who are being subpoenaed or who are witnesses, who don't want, in other words, they have rights too. So the press has rights. They have First Amendment rights. But some of the parties to these cases can have rights too. And so you have to weigh the rights. And you just don't, deny it. And that's what the administrative judge wants to deny it, because he wants to control what goes on. And for probably the same reason that he tends to use only attorneys as SCAR hearing officers, even when they have no valuation experience. I had one who is a family law attorney. I don't know how that qualifies her to know how to value real estate. And we've got another attorney who does insurance. I don't know how that qualifies her either. But the reason that he likes to have attorneys is because he knows he can control them. Because, if they were to go against him, that would be bad for their career. So they'll do what it is that he wants. So, it's kind of outrageous. But the assessor nor the hearing officer, qualify for Civil Rights Law 52. It's for the public. It's not for the government. Section C, audiovisual coverage of party or witness testimony in any court proceeding, other than at a plea, at an arraignment, is prohibited. Let me read that again. Audiovisual coverage of party or witness testimony in any court proceeding is prohibited. Well, we know that's not true, because look at A. In order to maintain the broadest scope of public access to the courts, to preserve public confidence in the judiciary, and to foster public understanding of the role of the judicial branch in civil society, it is the policy of the unified court system to facilitate the audiovisual coverage of court proceedings. Whereas C says it is prohibited. These things are quite contradictory. So that is unconstitutional. Now it being prohibited by restrictions of the civil rights law, well, that's true. And in criminal cases and matrimonial cases, there can be people that need to be protected, by the civil rights law. But in assessment hearings, there's no parties to protect. The assessor and the hearing officer have no expectation of privacy. They are the government. The government does not have civil rights, protections. If they don't like to act in a public capacity, they shouldn't be taking the job. 131.1D, nothing in these rules is intended to restrict any pre-existing rights of the news media to appear at and to report on judicial proceedings in accordance with law. Yeah, so they're backtracking on this one. And so, they're saying it's not intended essentially to infringe upon the First Amendment of the Constitution. And we'll get into the case law that they reference, after I keep beating them up on these previous ones. Let's go on E. Nothing in these rules is intended to restrict the power and discretion of the presiding trial judge to control the conduct of the judicial hearings. So the judge needs to maintain decorum and keep the under control so people can get a fair trial. But you can't use this to violate people's rights. F. No judicial proceedings shall be scheduled, delayed, reenacted, or continued at the request or the convenience of the news media. So anyway, that's fine. They have to meet the schedule. So then, 131.1 doesn't work. So let's try 131.3. Coverage of judicial proceedings shall be permitted only upon order of the presiding trial judge approving an oral presiding trial judge, not the administrative judge, the presiding trial judge. In this case, it's a hearing officer. Approving an oral or written application made by a representative of the news media for permission to conduct such coverage. Okay, so I submitted that form and I applied for it, and of course, they deny it because they said so, but they don't have a legitimate reason to deny it. B, upon the receipt of an application, the presiding trial judge shall conduct such review as may be appropriate, including 1, consultation with the news media applicant. That was never done. That couldn't be bothered. See, part of the problem with this administrative judge, Eugene Faughnan, is that he thinks the small claims assessment review program is beneath him. He doesn't have time for this stuff because he's too important. He's good enough to collect the $220,000 a year that he's paid to administer the SCAR program, but he thinks it's beneath it because he's a Supreme Court judge, and so he didn't conduct number 1, which he might have learned a few things had he bothered. 2, consultation with counsel to all parties to the proceedings of which coverage is sought, who shall be responsible for identifying any concerns or objections of the parties, prospective witnesses, and victims, if any, with respect to the proposed coverage and advising the court thereof. So, yeah, certainly he should include the assessor and the town attorney in this discussion. But the thing is, the assessor and the town attorney, they have no rights. So certainly they should be afforded the opportunity to make objections, but there are none that are legitimate. Section 3, review of all statements or affidavits presented to the presiding trial judge concerning the proposed coverage. Didn't bother. I sent emails and they just denied without with nothing other than it's so because they said so. They provided no legitimate. In other words, what they would do is they would cite 735, 131, Civil Rights Law 52, but they would not describe how they apply. They're just saying it's so because they said so. It's they need to do more than that. If they're going to deny my First Amendment rights, which is exactly what they're doing. So let's get into the civil rights law that they're using to deny across the board recordings of these hearings. New York State is alone. I don't know the exact statistics, but it's very common for these things to be recorded in many other states. New York State is the most restrictive, is my understanding. So here's the civil rights law. No person, firm, association, or corporation shall televise, broadcast, take motion pictures, or arrange for the televising, broadcasting, or taking of motion pictures within the state of proceedings in which the testimony of witness by subpoena or other compulsory process is or may be taken, conducted by a court, commission, committee, administrative agency, or other tribunal in the state. Well, and again, so yeah, that's a law that protects the public, but it doesn't protect the assessor and the hearing officer. No person, firm, association, or corporation shall televise. It doesn't say the court. Broadcast, take motion pictures, or arrange for the televising, broadcasting, or taking of motion pictures within the state of proceedings in which the testimony of witness by subpoena or other compulsory process is or may be taken. So this 52 is to protect people in matrimonial cases or rape victims or a child, but it's not there to protect the assessor so that the assessor is not accountable to the public. That's not what Civil Rights Law 52 is about. But Administrative Judge Eugene Faughnan just says, denied because of Civil Rights Law 52, even though 52 supports my position. So he's denied me on all these sections, saying that he can deny based on those sections, and every one of those sections supports my position. It's hilarious. So anyway, I finally get to the hearing, and the hearing officer is good enough to cite some case law. So I asked him to let me write it down so I can look it up later. Thing is, he should have brought it to my attention before the hearing so that I could analyze it and respond to it, but he didn't give me that opportunity. And again, he's violating, let's see, 131.13, consultation with counsel to all parties to the proceeding of which coverage is sought, who shall be responsible for identifying any concerns or objections. And they didn't give me that opportunity. They just cite this case law, and they never provided me a copy until in the hearing. And they're not going to. And this thing is quite extensive, and everybody's not going to sit around and wait for me, for an hour for me to read all of this. And meanwhile, I have 3 cops surrounding me for an assessment matter. And I want to remind you, previously I participated in about well over 150 cases, and they'd never been in the courtroom, and they'd never been with court security. This judge is using the court police to violate my First Amendment right. That's what he's doing, so that he doesn't have to be accountable to the public. That's what he's doing. It's official oppression under the color of law. So this is courtroom TV versus the state of New York. That's a case law that they cited. A pretty famous attorney represented court TV. And it says, the primary issue on this appeal is whether Civil Rights Law Section 52, which bans audiovisual coverage of most courtroom proceedings, violates the federal or state constitution. We agree with the Supreme Court and the Appellate Division therefore here is no First Amendment or Article 1, Section 8 right to televise a trial. On September 5, 2001, Court Television Network filed a complaint against the state on Robert Morgenthau in his official capacity as District Attorney of New York County, seeking a declaratory judgment that Civil Rights 52 is unconstitutional and enjoining the prosecutor's office from enforcing it. On July 15, 2003, Supreme Court granted summary judgment to defendants, stating the court declines to establish a constitutional rule in New York granting the media a right to televise court proceedings. The record is consistent with the traditional approach to New York courts to public access questions, giving great weight to fair trial concerns. The record also is consistent with New York's statutory scheme, which guarantees public trials, but gives primacy to fair trial rights. Moreover, to the extent any changes to the statutory scheme have been put into experimental use, these were initiated and reviewed by the legislature. A state constitutional rule expanding the rights of the media in New York to include the right to photograph and broadcast court proceedings would derail what is and has always been a legislative process. And so they're saying that Section 52 is not unconstitutional. But the thing is that what Court TV was trying to do was they're trying to be able to record any hearing, any criminal hearing, so on and so forth. And the thing is that in these criminal hearings, there are people that have rights that could be violated by them recording these hearings. So I can appreciate that it's not unconstitutional. But the thing is that, they're applying it, to all cases. So across the board, is it unconstitutional for the court to deny, Court TV or anybody to record? And so my suggestion is that I can appreciate the ruling that Court TV shouldn't be allowed to record any hearing that they want. It has to be reasonable, and it has to protect parties that have rights, civil rights as well. That's why they call it Civil Rights Law 52. But it depends on the particulars of the case. And so they're saying that it's a matter for the legislature. Well, the legislature already created Civil Rights Law 52, and Civil Rights Law 52 does not preclude, is not there to protect assessors. It's there to protect the public, and there is nobody to protect in these assessment cases. So they're trying to, they want to just paint a brush across the whole thing, that it's denied, and that's not what it says. So I can appreciate why Court TV lost this case, but they should be able to record on a case-by-case basis. And if the judge denies them, and his explanation for why they can't record it is not reasonable, they'll have standing to sue. Until the courts can behave reasonably. It has to be reasonable. If there's no one to protect, they cannot deny it. The Appellate Division affirmed Court TV appeals as of a right on constitutional grounds pursuant to, CPLR 5601. Court TV asserts that Section 52 denies it the right of access to trials guaranteed by the First Amendment of the United States Constitution and Article 1, Section 8 of the New York State Constitution. Court TV argues further that most states permit televised trials, and that's where the problem is. That New York stands alone in having an absolute ban on televised trials, and that the evidence supporting access to information for the general public far outweighs any attendant problems of having cameras in the courtroom. And that's the problem, is they have an absolute ban, even though Section 131.1A says it's their policy not to do it, because it would be inconsistent with the civil rights law. New York State counters that there is no First Amendment right to televised trials, and that the concerns of court TV are more appropriately directed to the legislature than to the courts. And like I said, it's already been directed to the legislature, and the Civil Rights Law 52 supports my position. The state, so on any individual case, the media who wants to record the hearing, or the public for that matter, is to submit a form to provide the information that the court would have to make a reasonable decision on the situation. So if there's a child to protect, they're going to be denied. If the defendant in the criminal trial doesn't want it, then that has to be weighed. And so it's on a case-by-case basis. It would be, in my opinion, unconstitutional to globally deny every case. It's just not appropriate. The state additionally argues that allowing cameras in the courtroom is a discretionary policy determination that may be made by the legislature. And that's the case. And that's probably true of police body cameras, too. It's not a constitutional right for the public to demand police cameras, I think that's legislative. But the First Amendment of the United States Constitution guarantees the press and the public a right of access to trial proceedings. So if you want to go in person to a hearing, you can, and you have a constitutional right to that. But they're saying you don't have a constitutional right to record it. And I say that you do have a constitutional right to record it, with exceptions, and per Civil Rights Law 52. Without the right to attend trial. So again, denying globally these hearings to be recorded is unconstitutional. Without the right to attend trials, which people have exercised for centuries, important aspects of freedom of speech and of the press could be eviscerated. So in my case, the judge was allowing the public to participate. The administrative judge, which is not his job to do, was allowing the public, but he was not allowing the public to record. And so the only difference is the recording. And I think that's unconstitutional. So in other words, he's allowing the public to go to the hearing. It doesn't matter if there's a rape victim, a child, or whatever. He's allowing it, but he doesn't want it recorded. So it comes down to the only issue in my case is that he doesn't want me to record it. And unless he can come up with a reasonable, articulate explanation as to why, that would be unconstitutional. Okay, let's see. Though the public acquires information about trials chiefly through the press and electronic media, the press is not imbued with any special right of access. We've already gone through this. In other words, the media doesn't have more access to these cases than the public, or vice versa. What more do we have here? The court listed a number of concerns about the presence of cameras at the trial, including the prejudicial impact of pre-trial publicity on the jurors. Well, see, here you go. In each individual case, it has to be weighed. You can't globally deny it. The impact of the truthfulness of the witness responsibilities placed on the trial judge to assure a fair trial and impartiality of the defendant. So what happens to happen is you submit the application, and the judge hears from both parties, what their arguments are for and against the recording of it, and he has to make a determination. And if his determination turns out to not be reasonable, either side would have standing to sue, to try to correct these things. The court wrote, a defendant on trial for a specific crime is entitled to his day in court, not in a stadium or a city or nationwide arena. Well, I'd say if you're a defendant in the murder trial and you want the thing to be recorded, instead of the court just sweeping it under the rug, I'd say you do have an absolute right to do that. But if you don't want it recorded, you have you do have some reasonable input. And if the judge's determination is not reasonable, then he would have standing. The court did acknowledge that the ever-advancing technologies or techniques of the public communication and the adjustment of the public to its presence may bring about a change in the effect of telecasting upon the fairness of criminal trials. And again, it's about the fairness to all the parties, and he has to weigh that, but he can't blanketly deny it. Thus, it is clear the federal Constitution does not require courtrooms to be open to televised proceedings. Well, I think that's not necessarily true. Similarly, does not provide the right to televise trials. Every citizen may freely speak, write, and publish his or her statements on all subjects, being responsible for the abuse of right, and no law shall be passed to restrain it. And you record it and you say what you want, but you are you can't just say whatever you want. You're subject to libel and slander laws, so on and so forth. It concedes, however, that this court has not explicitly recognized a state constitutional right to public and press access to trial court proceedings. While we have in certain circumstances interpreted Article 1, Section 8 more broadly than its federal counterpart, we decline to do so here in New York. In New York, the press, like the public, has a right of access to criminal proceedings. Government has the burden of proving that government interest outweighs the constitutional right, and that's what I'm saying is that they have to articulate. They can't just blanketly deny. The primary governmental interest, both state and federal, is guaranteeing that the defendant receives a fair trial. And consistent with that interest, the court must be concerned with the defendant, jurors, witnesses, attorneys, and the public at large. And that's true. But again, there are none to protect. It's the assessor. It's the hearing officer. So I think that's pretty much all the points to it. Despite the technological improvements to audiovisual equipment, which renders its presence in courtrooms less obtrusive, the legislature has not seen fit since 1997 to amend Section 52. So Judge Faughnan is basically saying you can attend it in person, but you can't record it, but he won't say why. And so it's not practical for the entire public to go to these hearings, and so that they can get an understanding of what goes on in their government, and that's what he's trying to restrict it. He's trying to restrict it because it's all about power. He's trying to maintain the power of the judiciary. If the judiciary were always recorded, they'd be less able to do whatever they darn well pleases, which is exactly what Eugene Faughnan is doing in this particular case. So it's my objective to bring this to the public's attention. We will not circumscribe the authority constitutionally dedicated to the legislature to determine, and again, the legislature has already done it, whether audiovisual coverage of the courtroom proceedings is in the best interest of the citizens of the state. The state constitutional rule expanding the rights of the media in New York to include the right to photograph and broadcast court proceedings would derail what is and always has been a legislative process. So anyway, Civil Rights Law 52 provides in part no person, firm, associate. We've already been through this. 2, since there is no pending action by the district attorney, okay, it's not relevant. 3, we note that after Chandler, no federal circuit court has opined that the federal constitution guarantees the media right to televised trials. The sittings of every court within this state shall be public, and every citizen may freely attend the same, except that in all proceedings and trials in cases of divorce, seduction, abortion, rape, assault with the intent to commit rape, criminal sexual act, bastardly, or affiliation, the court may, in its discretion, exclude therefrom all persons who are not directly interested therein, excepting jurors, witnesses, officers of the court. And that's reasonable. I don't think that the public should be, in matrimonial cases. When you're accusing, if you're going to put somebody in jail for 50 years or life, it shouldn't be done in secrecy. But that's not what we're talking about here. We're talking about assessment hearings, for God's sake. The most public of all things, assessment. They want it to be, private. So I think that pretty much covers it. So the bottom line is that they have to articulate a reasonable explanation to limit the access. Section 52 is a civil rights law to protect people, to protect victims, to protect defendants, so people can get a fair trial. It's not about protecting the assessor, And so again, he said I wasn't a legitimate member of the press. We've reviewed that. There's no difference between the press and the public. The public has a right to access these hearings, as does the media. 735, determination that precedent, a video recording is not a transcript. Tran as in translate, script as in write. Translate to writing is what a transcript is. It's got nothing to do with video recording. It's ridiculous. He's just using the vague nature of it for his own agenda. 131.1. In order to maintain the broadest scope of public access to the courts, to preserve public confidence in the judiciary, and to foster public understanding of the role of the judicial branch in civil society, it is the policy of the unified court system to facilitate the audiovisual coverage of court proceedings to the full extent permitted by the New York State Civil Rights Law. And again, the Civil Rights Law protects the public. It doesn't protect assessors. The administrative judge is making determinations for the judges. That's what judges are for, to weigh the evidence. And the administrative judge didn't bother. He just so because he said so. If the hearing officer went through 131.3 and he did all those things and he still denied me, well, that would be one thing. But still, his denial would have to be reasonable. Civil Rights Law 52, we've gone through that. And then here's the case. This case it covers a lot of the elements of what it is that we're talking about, but it's a completely different circumstance. We're not looking to record capital murder cases or rape cases or cases involving children. It has nothing to do with that. It's assessment matters. They have no right to deny that. It's just the administrative judge trying to make his job easier. He's making $220,000 a year, and he can't be bothered to follow through with the STAR process and do it properly because it's apparently beneath him. This is Mike Franklin, a property tax guy. It's beneath him in violation of my First Amendment right. Mike Franklin, a property tax guy.